Alrighty, so everybody's up. So there may be some background noise because I'm not doing this at midnight, 1 o'clock, 2 o'clock, 11 o'clock in the morning hours, late hours. All right, so this is live for Sovereignty Living, right? And let's see here. Everybody asks questions of common law, in which there is common law words, wrongdoer, and all that. Oh, don't do that. Hang on. I'll pause that there. Yeah. We the people, of course, this is a lawsuit. So the people is bringing action versus, okay? So the people, we the people, we are demanded, complainted, whatever, right? We're not pro se or uh, defend it, and then we're not the plaintiff, right? Uh, we, the people, going after the wrongdoers. That is a common law words. So he's bringing a lawsuit against the bar union here in Texas because they keep violating our rights, passing on stupid, unlawful laws, and are helping. Okay, your legislature, some of them bar members. Well, what are they passing? Things that helps them, not the people. Okay, sit and think about that. Congress. If you got bar members in Congress, what are they doing? Passing laws that helps them, never the people. Okay, read some of these laws. It's the trickery of words, thinking that you're getting rights, but they still hold off for state power or Congress power. And let's go ahead and again, this is Diesel We the People News. Oh, P.S. So if you want to check out the case, there you go. Okay. And I shouldn't do this, but I'm going to just in case you're on a small phone and you're not on TV. Alrighty. Now he did uh, he's taken a lot of his draftings from the 10th Circuit Court that did this in common law. And when the attorneys and him were fighting and all that, well, the attorneys could not say a whole lot because that was the wrong jurisdiction. He put it in common law. So there was a case on this in the 10th Circuit that, sorry, state, wrong jurisdiction. He's in the common law. All right?
I have to approve all comments. Sometimes it takes time for me to do that. So this is a document that I filed in my lawsuit today. The way it works in the federal court is they give you a wannabe judge. Well, you don't have to accept it. Matter of fact,
And the wannabe judge is what we've been talking about for a long time now, right? Administrative. That's a wannabe judge. They're administrative magistrates.
tomorrow I'm going to file a notice of objection to the wannabe fake judge. Anyways, so then the real judge will have to take over.
Which is where you get your remedy, the judicial branch, not administrative. You can get some remedy by compromise, but to really get the real justice would be under the judicial branch, which, again, this is the reason why you challenge jurisdiction of the courts. Which jurisdiction am I under? Administrative, or judicial? You can stretch it out even further. Merchant, that's a jurisdiction. That's a certain type of jurisdiction. Which jurisdiction am I under?
So what they do is at some point the judge, whoever it is, if he's a wannabe judge, he'll make findings, conclusions.
And amity is another jurisdiction, So they do this to really confuse us all.
And recommendation.
So there we go.
Won't get into the appeal record, nor this, I don't believe. What'll get there is this, the brief, when you attach a brief. So you can sit there and make a motion and make all sorts of arguments, and it doesn't, I've actually had the courts dismiss a case, the Court of Appeals, because there was nothing for them. There was no appeal record. They're supposed to, what happens when you appeal it is the district court will send the record to the Court of Appeals, and then you can't bring up anything other than what you've already brought up. And so I've been doing that is basically building a case for the appeal. Because if there's any place you get your rights violated, it's in these so-called courts. So this is actually, the way it works in the federal courts is that if you can keep your brief under 10 pages or under, then you don't have to have a table of contents or a list of authorities. If your brief is more than 10 pages, then you have to have a table of contents and a list of authorities. And so this brief is, and then it doesn't include the attachments. Okay, the attachments is separate. And so, and they don't want any footer. All you can do is put a page number on it, and that's it. So this one has a table of contents, and it's supposed to be an alphabetical list of authorities. So these are all the authorities and the pages that it's on. That's a bit of a pain in the butt to put this together because I have to, the Word doesn't allow you to make them alphabetical. It's a bit of a nuisance. So, I just manually do it. It's a bit of a nuisance because I got to print off the table of contents and then go through and check all the page numbers and make sure that I got them down right. And then if I make any changes, it causes all the page numbers to change. So this is it's 25 pages. I'm not allowed to have a maximum of 25 pages for the brief, excluding the table of contents and the list of authorities. And so we have basically 5 pages of that. So then the brief is 29 pages. Anyways, so the first paragraph. So it starts off. It says, "Come now, demands notice in Court of Objections to the magistrate judges." So the purpose of this is for the Court of Appeals. Okay, so he's already trying to dismiss it. He's recommending that the court dismiss it, that the real judge dismiss the case. And so I filed this today. You have 2 weeks after they do their findings and conclusions. You have 2 weeks to object to it. And so, and if you don't do it within 2 weeks, then you can't even appeal it. So you have to get it in there within 2 weeks. So buyer's fake judgment. That's the judge in the lower court. I'm doing a collateral attack on her fake judgment. So the demand and file this action is a collateral attack because of buyer's fake judgment that fails to have a court seal on it. Okay? If there's any court under the Authentications Act, it's supposed to have a court seal on it. And it's supposed to be signed by a judge. It is signed by a judge, but there's no court seal. Therefore, it fails to be a court, and is evidence that Byers was acting in her private capacity only on hire for her bar buddies, under color of law, true copy of which is attached here to it in the appendix at pages 48 through 50, all of which is incorporated herein by reference in its entirety. So you got to incorporate it in because they play stupid, you know. Anyways. Byers' 97 District Court might have had jurisdiction, but lost subject matter jurisdiction through denials of due process of law. A court's jurisdiction, though existent at the beginning of a proceeding, may be lost in the course of the proceeding by deprivation of constitutional rights. Thereafter, the court no longer has jurisdiction to proceed. A judgment rendered.
Okay, so question, right? You could do a court of appeals, but when you challenge jurisdiction, but you never get clarification of jurisdiction and say case, well, the courts cannot be moved. It's at a standstill. So everything is unlawful. So therefore, how can you do appeal if that court cannot be moved? It's null and void. All right, and if it's null and void, there's no particular place to go. So, you know, it's one of them tricky things. The way it can be moved is if you throw a lawsuit. Well, that's fine and dandy. However, if you don't do nothing, and even the order's still in there, it's still null and void. It's so you can go home and allegedly, by all rights, they can't never touch you because they never have jurisdiction or clearly established jurisdiction that you are supposed to be aware of, right? This is the reason why some of these people out here, you hear them saying challenging jurisdiction. Well, we can't proceed forward. Well, no, they can't. So that particular type of court is mute. It's null and void. It has no place to go.
In violation of due process is void, and the rendering state is not entitled to full faith and credit elsewhere. Due process requires that the defendant be given adequate notice of the suit and be subject to personal jurisdiction of the court. Denials of due process of law. Byers' fake court clerk, Robin Woods, refused the demandant's filings as evidenced by the unclaimed. Returned certified mail, which contained a challenge to jurisdiction as evidenced by the image of the unclaimed envelope, the challenge to jurisdiction, certificate of service, and the website, true copies of which are attached here too in the appendix, pages 751 through 71, all of which is incorporated herein by reference in its entirety, and we'll look at that after. Matter of fact, we can go look at it now if you want, 51 through 71 in the appendix. So the way you're supposed to do the appendix is you just sequentially number the pages. And so you'll see how I did that. So this is page 8. Yeah, that's Byers' fake judgment right there. See here? There's no court seal on it. So this is page 8. Yep. That's Byers' fake judgment right there.
There's that.
See here? There's no court seal on it. See? That's it. That's all of it. 3 pages. So it's a fake judgment. And then This is all of it, 3 pages. So it's a fake judgment. And then
Shit.
there's no court seal on it.
Nah. This is for my benefit as well, y'all. That's the reason why I'm trying to stick to that.
See, that's it. It's all of it. 3 pages. So it's a fake judgment. And then this is what was in that envelope.
I'll try to do it later. Hopefully it sticks.
Of course, they don't want that because they want to presume jurisdiction. There was a start chamber. See, the page numbers are sequentially numbered here. Here's the certificate of service. Certified mail on the attorney and the bar member scum. And they got it. And they knew that they got it. And they said it's just a railroad job is all it is. Anyways. And here's the certified mail saying that she got it. And here is the returned mail, unclaimed. Trish Coleman Byers, fake judge, eh? And here's their website. It said Post Office Box 167, Montague County. That's where I sent it. So
All right. This will be the People News.